Here are two of the biggest misconceptions that I hear as an Australian family lawyer. One, parents incorrectly assume that there's a presumption that the children will live with each parent equally, so 50-50 following separation. This is not the case. How a court decides what is in a child's best interest is set out in Section 60cc of our Family Law Act. Whether an equal time parenting arrangement is appropriate will depend on the unique factual circumstances of the particular case. People often incorrectly also assume that the court automatically favours women and that children will automatically be ordered to primarily reside with the mother. There are many circumstances where the court might form a view that it's in the child or children's best interest to, in fact, live primarily with the father. More traditionally, it was common for the wife/mother to stay home and be primarily responsible for caring for the children and the home. However, these days, it's quite common, and I've dealt with many matters where it's actually the wife who is the primary financial contributor. She earns more money, and it's the husband/father who stays home and primarily cares for the children. And often in those cases, the court might form a view, or the parties might agree, that the children should continue living primarily with the father post-separation. And to be clear, each case will turn on the unique circumstances and facts of the particular case. There's no presumption either way. Primary attachment and the care arrangements prior to separation and post-separation are one of several factors the court will consider. The court will also want to make orders that promote the safety of the child or children and each parent. The court will also consider any expressed views from the child or children, and the court will afford more weight to those views the older and more mature the child is, and if the court is satisfied that those views have not been influenced or coached. A child or children's expressed views are not binding on the court, and there are many circumstances where a court might make orders that don't follow the child's expressed preference. Court will also consider each parent's capacity to meet the child or children's needs. Misconception number 2 is that people incorrectly believe that when we consider the property pool for distribution in a property settlement matter, that we consider the property pool at the time of separation, and that any value or any changes in the property pool post-separation are not considered. That's incorrect. When we consider the property pool, we take a look at the items that exist and the values of such at the current time, so when we're doing the settlement or at the time of the hearing. Two primary reasons for this is because contributions continue post-separation. Things don't automatically freeze at the time of separation. And also, considering the property pool and the values of such at the current time avoids a situation where we'd be considering a property pool that doesn't exist. For example, if we froze things at the time of separation and it has been a year, 2 years, multiple years since separation, we might be dealing with an entirely different property pool. That's not to say that your ex is automatically entitled to things post-separation. Post-separation contributions are considered, but we do take a look at the property pool that exists at the current time.